Good morning and welcome to today's New York City Council hearing for the Committee on Oversight and Investigations. If you would like to submit testimony, you may testimony at council.nyc.gov. At this time, please silence all electronic devices. Just a reminder, no one may approach the dais during any point at this hearing. Chair, we are ready to begin.
So good morning. I am Gail Brewer, Chair of the Committee of Oversight and Investigations. I hope that soon we'll be joined by my council colleagues, but in the interim, I want to state that our committee will be conducting oversight regarding the Department of Investigations, New York City's marshals. As some of you know, marshals are private citizens appointed by the city primarily to enforce orders from civil court cases, including collecting on judgments, towing, seizing utility meters, and carrying out evictions, which is fortunately or unfortunately what they're known for. Marshals collectively perform approximately 25,000 evictions per year. Obviously, during the pandemic, it was much less, and we'll see what it is today. Their work and oversight of it are of great interest to tens of thousands of New Yorkers. As private citizens, not city employees, marshals tend to have their most profitable years during times of economic hardship for many others, which of course is challenging for all of us. Critics claim that this system, in which politically connected citizens appointed by the mayor, and obviously that could be discussed as whether they are politically connected, they're often known to each other in any case, they are allowed to keep a portion of the debts that they collect, and that could incentivize aggressive debt collection strategies. The marshals recorded their highest grossing year in 2009 during the worst part of the Great Recession. The city's 31 marshals collected a net income of about $11.6 million in 2022, which was a lot less than in 2009. The New York City Independent Budget Office has calculated that making city marshals city employees would yield $11 million in annual revenue. Nevertheless, the system persists despite the fact that the primary difference between marshals and sheriffs is that sheriffs are salaried employees of the city and marshals are private entrepreneurs. And I think most people don't know that, but we know it. The Department of Investigation has only limited oversight of marshals, which are not technically part of city government. They are a creation of state law. DOI has several relevant supervisory abilities, however, including the power to conduct investigations into marshals' activities, examine their books, records, promulgate directives concerning the official records kept by them, and procedures for performing their official duties, as well as the power to discipline them. And I have to say, in constituent work, we do find that some of them in their offices are excellent and polite and professional, and others are not. Today, I look forward to hearing from the Department of Investigation and interested stakeholders regarding the agency's oversight of the city's marshals. This committee seeks to learn how DOI conducts its oversight, the financial and other resources DOI has at its disposal to conduct its oversight of marshals, and recommendations that DOA may have regarding the overall performance and future roles of the city's marshal. And if there's anyone from the public, their experiences interacting with the marshals would be helpful, and any improvement ideas. I would like to thank all of the committee staff for their work on this hearing, including Nicole Catal, who's the legislative counsel, certainly Erica Cohen, policy analyst, Alex Yablon, policy analyst also, and Owen Kutowski, finance analyst. I'd like to thank Sam Goldsmith from my office. We will now hear testimony from Commissioner of the New York City Department of Investigation, Jocelyn Strouber, and I will turn it over to committee staff to swear in the commissioner. Thank you.
Thank you, Chair Brewer. We will now hear testimony from the administration. Before we begin, I will administer the affirmation. Commissioner Strouber, please raise your right hand. Do you affirm to tell the truth, the whole truth, and nothing but the truth before this committee, and to respond honestly to council member questions?
I do.
Thank you. You may begin when ready.
Thank you. Good morning. My name is Jocelyn Strouber, and I serve as the Commissioner of the Department of Investigation. Thank you, Chair Brewer, and anticipated members of the Committee on Oversight and Investigations who may join us this morning for the opportunity to discuss with you DOI's oversight role of the New York City Marshals. As I will explain, and as you alluded to in your statement, Chair Brewer, DOI's authority and oversight of the City Marshals is conferred by state law through delegation by the 1st and 2nd Department of the Appellate Division. DOI is thereby authorized to supervise the marshals, which includes the investigation of their conduct and activities and the issuance of procedures for performing their official duties. The Appellate Division retains a role in DOI's oversight of city marshals, and, for example, must be notified of and in some instances approve DOI's directives to the marshals. DOI's authority does not extend to substantially affecting or delaying the court orders that the marshals are tasked with executing. Today, I will describe the scope of our authority with respect to the marshals, as well as their roles and responsibilities. New York City Marshals are officers of the New York City Civil Court, tasked with enforcing the orders issued by that court. They are not DOI or city employees, and they operate their businesses independently of the city. State law vests supervisory and disciplinary authority over the marshals in the State Appellate Division for the 1st and 2nd Judicial Departments. Those bodies have delegated their day-to-day authority over the marshals to DOI, mainly through the 2 joint administrative orders 453 and 456, which generally define our authority. I have attached those to my testimony today. Pursuant to state law, city marshals are appointed by the mayor for 5-year terms. The law allows the mayor to appoint up to 83 marshals. There are 28 city marshals today. The Mayor's Committee on City Marshals handles the marshal appointment process. The committee consists of 15 members, 6 selected by the mayor, 6 chosen by the Appellate Division, and 3 selected by law school deans in New York City. The committee establishes criteria for city marshal appointments, recruits candidates for that office, and after vetting candidates, recommends appointments and reappointments to the mayor. With respect to DOI's role, and beginning with the appointments process, DOI provides administrative support to the Mayor's Committee on City Marshals. That includes receiving and reviewing applications and resumes, organizing interviews with applicants, conducting background investigations of candidates, preparing reports of a marshal's history in office for reappointments, and preparing letters of recommendation from the committee for the mayor's review. DOI's oversight of city marshals commenced in its present form in 1968, when the Appellate Division for the 1st and 2nd Judicial Departments delegated some of their supervisory powers with respect to the marshals to the Department of Investigation. In the mid-1970s, the court issued the 2 joint administrative orders I mentioned earlier, and which you have copies of, formally setting forth DOI's supervisory powers, including the power to investigate the marshals' activities and impose discipline where warranted, examine their books and records, direct them with respect to maintenance of official records, and issue procedures for performing their official duties. As part of its supervision, DOI has issued numerous directives concerning standards for marshals' official conduct and for the maintenance of official books and records. For example, DOI has issued directives to marshals on issues such as maintaining a year-to-date count of completed evictions, possessions, and ejectments, and the existence of the 2019 Housing Stability and Tenant Protection Act, which introduced a 14-day notice of eviction rule, requiring marshals to serve a notice of eviction to tenants and then wait 14 days before executing an eviction warrant, among many other directives. DOI is required to provide copies of these directives to the Appellate Division, and they are deemed approved unless the Appellate Division nullifies them. DOI has also prepared a handbook of regulations, which was last updated in 2013, set forth in DOI's directives to the marshals through the years, and is publicly available on our website. The regulations developed by DOI generally relate to marshals' official conduct, discipline, record keeping, and the execution of evictions and levies. DOI is completing an updated version of the handbook to reflect statutory changes that have been made over the past decade, as well as adding to the handbook the DOI directives issued to the marshals since 2013. The handbook of regulations must be reviewed and approved by the Appellate Department. as well as any substantial policy changes therein, if any. DOI carries out its oversight of the marshals through its Bureau of City Marshals, a 4-person unit within DOI consisting of a director, investigator, auditor, and administrative assistant. The unit reports to DOI's General Counsel. In addition to the responsibilities described above, DOI's Bureau of City Marshals engages with the civil court regularly with regard to matters of eviction, seeking clarification of eviction orders when necessary to ensure marshals are following the rules, and assisting the court with decisions regarding citywide eviction suspensions due to weather or other extraordinary circumstances such as the COVID-19 pandemic. DOI's primary role in these matters is to convey to the marshals the directives imposed by the courts. DOI also shares that information with the public via our website. The Bureau of City Marshals also conducts investigations into allegations concerning marshals' conduct. Those investigations have resulted in discipline ranging from informal warning letters, letters of admonition, and letters of stipulation. The Bureau receives complaints from members of the public, including individuals subject to eviction. Investigations of a marshal's conduct are handled much like any other DOI investigation. We may review relevant documentation, collect evidence, including where available, video or photographic evidence, and interview witnesses, among other investigative steps, depending on the nature of the matter, and follow the facts as we do in every case. DOI has authority to impose penalties, including suspension of a marshal's badge, a monetary fine, forfeiture of fees collected, and removal from office. DOI cannot make unilateral decisions regarding removal of a marshal and must file charges with the appellate division regarding these matters. DOI must also make the appellate division aware of any stipulations entered against a marshal, such as a stipulation ending in a marshal's resignation. Since 2019, DOI has received 550 complaints, conducted 30 investigations, and taken disciplinary action against 11 marshals, including a disciplinary stipulation in November 2019 that resulted in a marshal's resignation. DOI's public website provides information about the marshal's responsibility to execute evictions and collect money judgments, as well as information about DOI's oversight role. With respect to the work of the city marshals, as officers of the civil court, marshals primarily enforce court orders, including warrants of eviction, collections of money judgments, and utility meter seizures when a utility company has received a judgment to reclaim their meter from customers who have failed to pay their bills. Marshals participate in the boot tow program for the City Department of Finance, enforcing judgments for the city's Parking Violations Bureau by placing a boot on vehicles for seizure due to non-payment of violations, including parking tickets and camera violations. Marshals also conduct vehicle auctions of towed vehicles that have not been reclaimed and that have outstanding judgments. The Department of Finance promulgates a standard operating procedures manual, which includes the rules and regulations under which participating marshals operate in the boot tow program. Some marshals also enforce the collection of Environmental Control Board fines on behalf of the Department of Finance. Marshals do not serve summonses. Marshals can be hired by private litigants to enforce judgments issued in their cases, and in that event, they are paid by those litigants. The Department of Finance and the New York City Housing Authority, as noted, also hire city marshals to execute judgments. Marshals' fees are set by state law and are specific to the services that they provide. By law, marshals retain 5% of any money they collect on court-ordered judgments. They are required to remit an annual assessment fee to New York City consisting of $1,500 plus 4.5% of their gross income. Over the past 5 fiscal years, those annual assessments have brought in nearly $6.2 million to New York City's revenue base. Marshals perform some of the same functions as the New York City Sheriff's Office, whose staff are city employees under the umbrella of the Department of Finance. The Sheriff's Office can enforce eviction orders of both the Supreme and civil courts. The marshals can only enforce eviction orders of the civil courts. The fees for city marshals and the city sheriff are the same, and the sheriff's fees also are set by state law. It is important to note that DOI does not direct work to the marshals and does not and cannot influence how many and what type of orders the marshals enforce. The nature and quantity of a marshal's work is based on those who hire them. Each marshal annually submits to DOI their fees and their yearly financial statement, a month-by-month summary of all sums collected and disbursed by the marshal, and a statistical summary of the marshal's official activities in the preceding calendar year. The Bureau of City Marshals audits those financial statements and reviews any requests for any unclaimed funds, which are generally funds where, for instance, an employer garnishes more wages than the debt requires, or a car has been sold at auction for more than the outstanding judgment. With respect to evictions, city marshals are authorized to carry out eviction orders by the civil court, which is where most eviction cases are brought in New York City. The city sheriff is also authorized to carry out civil court evictions, and private landlords, the Department of Finance, or NYCHA can hire a city marshal or the sheriff to carry out an eviction order. DOI plays no role in that decision. Pursuant to state law, when a city marshal is asked to carry out an eviction, the marshal must first request that the court issue a warrant of eviction. After a warrant is issued, but before it is executed, the marshal must serve the tenant with a notice of eviction and then wait 10 days to carry out the eviction. 14 days. In cases where a tenant would like to delay an eviction, their recourse is to move for a stay on the warrant of eviction in housing court. Alternatively, a tenant can communicate with their landlord to request additional time before an eviction, but that determination would be left to the landlord's discretion. DOI does not have the authority to delay an eviction or otherwise control the timing of an eviction, except in one limited circumstance, when a referral to Adult Protective Services, or APS, is warranted. Pursuant to the Marshal's Handbook, before conducting a residential eviction, a marshal must find out whether the resident of the apartment is unable to take care of themselves, such as a disabled, elderly, or infirm adult. If so, the marshal must notify DOI, which then notifies APS. Again, by state law, the eviction is then delayed for 2 weeks, during which time APS assesses the tenant's needs and eligibility for services. APS can also make requests to DOI to have a marshal delay an eviction of an APS client. Since 2019, DOI has processed approximately 11,000 of these APS referrals. There are no other circumstances of which DOI is aware that result in the automatic delay of an eviction, with the exception of severe weather events or other extraordinary circumstances that can result in a suspension of citywide evictions, such as occurred during the pandemic. DOI understands the critical and sensitive nature of evictions and is discussing with APS whether there are any other proactive steps that DOI and APS can take, consistent with applicable state law, to ensure that all tenants facing eviction who need social services are captured through the existing APS referral procedure. Evictions executed by city marshals are searchable as part of an online public portal that is updated by the marshals and exists both on DOI's website and on the city's open data website. In 2023, there were 13,521 evictions executed by city marshals in the 5 boroughs. With respect to the collection of money judgments, both a city marshal and the city sheriff's office can collect on those judgment orders. Both can execute money judgments from the New York State Supreme and Family Courts. To collect on a money judgment, a city marshal must be given a court document called an execution, which can be provided by an attorney or the court clerk. This document provides the marshal with legal authority to enforce the judgment and collect an individual's income, money, or other personal property. To begin the collection process, the marshal must mail a notice of execution to the judgment debtor, informing him or her of the obligation to pay the judgment. Again, state statutes dictate precisely how a money judgment can be collected and what can be collected, and city marshals are bound by these statutes. Certain properties, such as welfare and Social Security payments, household furniture, and a residence security deposit held by a landlord or utility company, are exempt from collection under the law. I hope that this testimony begins to shed light on an extremely complex area that, as you note, impacts New Yorkers at a very critical and emotional moment in their lives, and also provides some fundamental information as to the law governing city marshals and DOI's oversight. I am happy to take any questions that you have.
Thank you very much for shedding light, I think, on a topic that most New Yorkers do not know. And interesting that you should be pursuing the APS angle, because even though, and I did not know this, that there is a relationship between APS and the marshals, but I can tell you we have 2 cases this week where it is clear, and I'm not going to mention the names of the marshals, but they were not aware that the individual, one mentally ill, one 81 and not in good shape, had, they were not referred to APS. So we did it with our own, but that's a problem, because in both cases, they're rent-controlled apartments paying, $300 a month, and of course, we think that that might be why they are under this circumstance. So I think that that APS link needs to be strengthened much more. Just even though you mentioned there were so many referrals, in these 2 cases, it wasn't clear that there was, the owner of the building did not make it clear that there were issues with the residents, for obvious reasons, and the marshal had not referred to APS. So I just want to make that, somebody needs to work on that.
Yeah, and one possibility here is that it can be the case, and it should be the case, that in the housing court proceedings, some of this information comes to light. And that can be another mechanism for referral to APS. That does not always happen, and one of the things that we're considering is whether there's guidelines or directives that we might provide that would help the court identify when a litigant is before them for a reason relating to, mental health, infirmity, et cetera. Now, sometimes litigants don't always appear in court, and a default judgment can be entered, so there's a lot of complexity here in terms of who has the information. But when a marshal arrives at the site of an eviction, even at that point, if they discover that the resident is elderly or unable to care for themselves, what happens routinely in that circumstance is they reach out to our office and confirm with us that the appropriate course is to refer the matter to APS. So that can happen even as far along in the process as the actual eviction itself. We agree with you that that's not the best way for it to happen, and it would be much better for that referral to occur well in advance so that APS has the time that it needs to address the needs of the resident.
Okay, and something to work on. I know you talked a little bit about the oversight of the marshals and what is entailed. Is there anything that you wanted to add to that? In other words, there are not a lot of marshals now compared to in the past. So the 4 people that you do have, is that enough to have the kinds of oversight that you think is appropriate? I was wondering if you think there should be more marshals. Is the relationship enough to have that kind of oversight, though, would be my first question. And is there anything, other kinds, you've talked about APS, but are there any other kinds of oversight that you think should be involved?
So with respect to the staff that we have and the current number of marshals, we think that it is sufficient. Obviously, DOI always could benefit from more staff in all areas, and the workload is significant. But we have a very strong group who are handling the marshals. And one thing that I do want to highlight, just to make sure that it's clear, is that on an annual basis, we are able to audit the financials of every single marshal. Now, obviously, the audit is a sample of the work that they do. I'm not saying we look at every single document, but the goal there is to ensure that their financial records are consistent with the court orders that we have, that they should be enforcing, and that the amounts that they are retaining and dispersing are consistent with the law. And we are able to do that, again, on a sample basis, but we're able to cover every single marshal and look at their financials. And at least I can say over the last couple years, when I've been here, we have not seen significant issues. Something may raise a question that we'll go back to the marshal with, but we are not seeing issues there, and we do think we have sufficient staff to cover that work. And similarly, with respect to the complaints we receive, and again, certainly in light of the current number of marshals, we feel that we have sufficient staff to cover that work.
Okay. I want to welcome Councilmember Rita Joseph. There are 31 marshals, as you indicated, but the mayor could appoint as many as 83. Do we know why there is a discrepancy? Now, of course, if you're a tenant and you are concerned about tenant rights, you would say 31 is fine, you don't want any more. I'm just saying, or if you own a car and you don't pay your tickets, then you would say that. But I want to know, that's a pretty big discrepancy as to what's possible. Is there any discussion? Are there enough marshals to carry out the required work? Is there some discussion with the mayor's office general counsel as to why they're not appointing more, et cetera.
So I actually have the number as 28, just
28,
you and I seem
okay.
to have a slight discrepancy
All right,
there.
28, yep.
You know, I understand that the Mayor's Committee on City Marshals, the current Mayor's Committee, was formulated this January, and so they are undertaking an appointment process. It's actually expected to begin this month. This is a matter within the mayor's discretion in terms of the number of marshals to appoint, and although we provide support in that application and selection process, we are really not involved in the substantive questions of how many marshals there should be. If issues were brought to our attention that suggest that there weren't enough, we could obviously raise those, but that's really not something that we're involved in or taking a position on.
Okay. It is a little strange, this procedure that you are a private citizen. It's state enforced, not city, so if there are any changes, it would have to go through the state. But you mentioned that sometimes the sheriffs do the work, sometimes the marshals do the work. So my question would be, obviously, they get to keep, as a marshal, 5% of any money they recover for the city. This, you know, would say to some tenant advocates that that makes an incentive to, you know, be aggressive about the debt collection strategies. Have you seen any of that? I think you indicated that in audits you have not seen anything like that.
We have certainly not seen in the audits that we've done that someone is sort of over collecting or taking more fees than they're entitled to. Certainly, as a general matter, in terms of aggressive strategies, historically over the years, we certainly have received some complaints, you know, that a marshal's not behaving the way we would want them to behave in terms of their interactions. It's not saying it's a frequent thing, but we have received those complaints historically, and we address those with the marshals, and they can result in the different forms of discipline that I mentioned. But overall, we are not seeing issues that suggest that there's unlawful strategies being used, unlawful retention of funds, any kind of over collection. We are not seeing that.
So there's no indication that the marshals are collecting, that they're collecting money that's actually owed and nothing above that. There's been no indication of that.
Not in the audits that we've done, no, we have not seen that.
Do you ever do what I would consider sort of investigation in the sense of just calling the offices? Because that's the complaint that I also get. Not that there's anything illegal, but just getting somebody to respond at the office, the professional way in which that communication takes place. I don't know, are there 28 different offices, or are some of them shared? How is that done? Because when one is in the field trying to get a discussion going with the marshal, you have to call an office. So, and as I indicated in talking to many tenant advocates I called, they said some are really polite and very professional, and others are not. So I didn't know if it's 28 different offices, or is it shared?
I don't know how the individual offices are structured. I know that each marshal has a staff, and I believe by law and by our handbook, they are required to have regular office hours of 8 hours each business day. And those hours have to be posted at the entrance to their offices. They can't, if they close their office before 5 p.m. on a business day other than a public holiday, they can't enforce eviction warrants the next day, so there is certainly incentives for them to maintain the office hours as required, and they have to notify DOI 24 hours in advance if they intend to close their offices. So I can't, you know, obviously I can't speak to the fact that someone may call and not get anyone at any particular time. There are only 28 of them, so they are busy,
Yep.
and they may not be available, you know, at every moment that someone calls. Thank you for that note. I understand that they do maintain different offices, but some do share physical office space, but each does have their own office, so there wouldn't be like a general phone number, for example.
No, I know, there are individual numbers that we're very aware of. I'm just saying that at some point it might be worth doing a, you know, just calling to see whether they are answering and how professional the staff is. Something, again, pretending you're the public, this, you know, even though they're private, they are certainly doing a public good or service. I don't know if it's good, depending on what they're doing, that needs to have attention. I'm letting you know that that is an issue that we get a lot of complaints about. I don't know if it's good or bad. You know, this is kind of a funny to have less revenue coming in, but in 2010, it was 21 million, as you know. In 2022, it was 11.6. And obviously, since the pandemic, the revenue has been decreasing. Now, in other cases, we might say, oh, this is a terrible thing. In this case, we might say, oh, good, nobody's getting evicted. But I don't think that's true. So I assume that the revenue is down because there are fewer evictions. Are there other reasons, do you think? Why would the revenue be down? Fewer marshals? Do you have some sense of that?
Well, certainly in terms of the city's assessment fee, that is, that went way down during COVID. It is higher this year so far in fiscal '24, and it was higher in fiscal '23 than '22. So it's gone up to some extent since COVID. It is down overall from a decade ago. In terms of the marshals' individual revenue, that could in part be a matter of how they staff and pay their staff. So it's a little hard to say. In terms of the city's assessment fee going down, that I do think is related to the fact that there have been fewer evictions. I think we're still in even though we've gone up since COVID, I think there are fewer than there were, and there may be other reasons. It's a little hard for me to speak to that exactly, the distinction between what's going on now and in 2010.
In the past, my understanding is some marshals made, I don't know, $1 million, and some obviously less. How does that work? In other words, how does the work get distributed? Is it I'm in Brooklyn and somebody else is in the Bronx? Is it whoever gets the call? Is the court makes the assignment? How does the work get distributed? Like, how would one person make $1 million and somebody else less?
So the court, as far as I'm aware, doesn't make these determinations. These are private litigants, or to some extent in the limited ways that I mentioned, city agencies who are selecting whether or not to use a marshal, and if so, which marshal to use. We don't have any involvement in that process, and therefore I don't have any insight unless anyone wants to pass me a helpful note. But I don't think we have any insight into how certain marshals have more business than others. Perhaps they've been established longer, they have more contacts in the community, but I'm really just, speculating here.
Okay, I didn't know. I would say, and did you indicate, maybe you did in your testimony, the percentage of revenue generated from evictions? Or is that something that is hard to delineate from the other?
We don't track our numbers by type of marshal action, so that is not information that I have. Anecdotally, we may be aware that certain marshals do more evictions, other marshals do more types of work just based on our contact with them, but that's our ad hoc sense. That's not a hard number figure.
Okay, so basically the way it works then is that if you are an owner or you or an agency, be it NYCHA or, like you said, Department of Finance, and you have a relationship with a certain marshal, then you would call that person to take care of whatever business is that you're concerned about. Or maybe that person has an expertise in that business.
Like I said, it could be. I don't know if they rotate in terms of a list. I just don't know.
Okay, I have to say it's a little strange. I'm just saying, a little strange. Do you think there are state-level changes to any laws that would make it easier for DOI to conduct oversight, or do you feel you have enough authority?
We feel we have enough authority. I mean, we're certainly open to, other thoughts if there are concerns out there that we're not aware of in terms of conduct, but I don't think at the moment we have any proposals for state law changes now.
Okay. And do you think that there are trends in marshal performance over time that you feel like you've done all the evaluation necessary, but are there any recommendations based on the oversight that you have done that could improve the way that marshals do their work, or do you think that would have to come from the state and from the court?
Well, fundamental substantive policy changes in how the marshals do their work at a minimum would have to be approved by the appellate division, and something potentially more significant would be a matter of state law. As I mentioned, we are thinking about the problem that you discussed as well, which is how to make sure that there's better information going to APS about a resident's issues that might warrant a delay of an eviction. So that's one of the main issues that we're thinking about right now in terms of areas where there could be improvement. That's not necessarily really a change in oversight, but it's a process-related issue.
Okay, and I assume you haven't, because this would be a state issue, but have you ever thought about have you done an evaluation whether it would make sense for the government to take the marshals in-house? Obviously, that would increase revenue, which I did not realize until I noted the IBO report. And keep, although there have been no abuses during your term, there have been in the past. Do you think that would still enable the marshals to enforce judgments? Would there be advantages, basically, to having sort of local sheriffs? Maybe you can't comment on this, because I know this is a state issue, but I just didn't know if that's something that had been thought of.
It's really not something that I've studied, and it's really not, at the moment, part of our role. I have seen, I think, some of the same literature that you've mentioned that suggests that the city might have an increase in revenue. On the other hand, there are other costs associated with making someone a city employee. I haven't really gotten behind those numbers, so I can't even say if they're accurate.
Okay. What kind of trainings do marshals undergo in order to do their role? Who trains them, and where do they train, if they do train?
They're trained by our office and by officers of the civil court. That's actually a requirement in the joint administrative order, which lays out some of the types of training that they're required to have, and it's on the various types of work that they do. Let me see if I can. So, for example, there's a series of lectures that they're given by, again, members of our office and by officials from the civil court. And they really relate, I can read them, but they really relate to all the areas of the work that they do. So maintaining books and records, how to execute warrants, the bank accounts they're required to maintain, how they maintain their financial statements. They have to either attend all the lectures in person, or they can review a tape recording of any lecture that they might have missed. They also receive a copy of our handbook, and they receive every directive as we issue them. We not only post them, but we send them out to the marshals, and they're obviously responsible for reviewing those and being aware of them. So that is the training that they get, in addition to the frequent contact with our office, which is often just, to confirm their sense of how they should handle a particular situation, like an APS referral or another sort of unexpected circumstance that might arise in the course of an eviction.
Councilmember, do you have questions? Go
Yeah, it's just one question. Thank you, Chair Brewer. Good morning. Happy to see you always. Thank you for this important work. I just have a question. DOI budget include funding for marshal programs. Could you please provide some information about what is encompassed within the funding for that program? Can you just break that down for us? Thank you.
Yeah, it's really all personal services. So at least the numbers that I have, and they may be a little different than the numbers in your report, they're not that far off. I have a personal services budget of $266,000 per year. That is for the 4 members of our Marshals Bureau. So that's a head count of 4 people. We have no vacancies in that unit at the moment, and the budget is really entirely for their salaries.
Thank you, and I'm sure Chair Brewer asked this. How many marshals do you have altogether for all 5 boroughs?
We have 28 currently.
To cover all 5 boroughs?
28 total.
Wow.
There have been as many. I think there can be 83. So it's a wide range. There are 28 at the moment.
And I think earlier you mentioned that are you planning to expand this? Is it something you're looking into?
So it's actually it's not within our authority to expand it or not, but there is a mayor's committee for the appointment of marshals, and that committee has recently convened. I described it's made up of a variety of appointees by the mayor, by the appellate division, and by law school deans, and they are currently in the process of reviewing applications. So there are the marshals that are currently working are in what's called holdover status, so they can in that process be reappointed. I would expect that many of them will be, and additional marshals could be added to that group. But that's within the discretion of the mayor and the mayor's committee. That's not a process we're involved in, and we don't take a position on how many there should be.
Of course, and do you have an idea what the timeline looks like?
I know that the committee is reviewing applications as we speak, but I don't have a sense of how long the process, will take.
Thank you so much. Thank you, Chair Brewer.
Thank you. Just on the training, is that in person? Maybe you haven't done it in the last couple of years because there haven't been any new marshals, I don't know. But is it in person or Zoom?
It is in person, and there's a requirement that if for whatever reason a marshal can't attend, they can then review a tape recording. I would assume if there were trainings during COVID, which I can't speak to, that
No, I'm
they would
talking
have been
about now,
remote.
yeah.
But the rule is that they're in person, and I think that's the standard.
Okay. One question that Legal Aid is asking is that legal providers are reporting that marshals are refusing to tell them when a notice of eviction was served. We want to know if the Department of Investigation would require the marshals to upload a copy of every marshal's notice they serve or reserve, whether by mail or personal service, on the website within 1 business day of completing the service. Is that something that you have considered?
We are in the process and have in the past worked on a portal that legal aid would be able to access, or that HRA, which is responsible for coordinating counsel in these circumstances, would be able to access, that could include that information. I believe there was some work done on that in the past. It's not clear to me that that portal is currently
It is not.
working as we would like it to work. So that is something that we are working on. That is different than issuing a directive to the marshals that would require that, which would be, you know, a different policy issue. But I think the point is that we are trying to make sure that there is an accessible way for that information to be available to counsel when they need it.
So what's the timing on whatever you are planning to do with the portal?
So our efforts are ongoing right now as we speak. I don't think that I can give you, you know, a specific time frame for when that can be up and running, but we're working on it right now.
Okay. And do you meet, or has there ever been a meeting with some of the legal aid and others, HRA, perhaps to talk about APS, to discuss the role of other ideas that might soften the blow for some of these challenges that are, faced by individuals? Do you have those kinds of discussions?
I mean, we're in regular contact with those, you know, with all of those folks, and we're certainly open to hearing, you know, ideas that they have to improve how the process works. You know, like I said, there may be limitations on our ability to affect those changes, but we're certainly open to having discussions with them and hearing what the concerns are.
Okay. So have there been marshal appointments during your tenure, or those 28 were just, I understand we're now waiting for new appointments, but as far as you know, there haven't been any new marshals appointed in the last couple of years?
There have not been.
Okay. And do you have any sense of what the quality or criteria is for being a marshal? Is that something totally in the mayor and the court? Or, I mean, obviously you review, but is there some criteria for those who are marshals? I don't know, I'm just asking.
There are criteria, and we also do a background check. But I don't, let's see, I don't know that I have a list of.
We want to welcome Councilmember Banks also.
Thank you. Okay. So there are minimum qualifications set by law. Those involve age, high school diploma, being a U.S. citizen, and being a resident within New York City, and then a number of the outlying counties. The committee considers candidates that have, proven records of occupational and educational achievement. So these are, folks who have established themselves generally in various areas. We've already discussed the training course, and they also have to demonstrate the ability to obtain a public officer's bond of $100,000 for their work and any liabilities that might arise. So there are minimum qualifications, and beyond that, the committee is really the decision maker as to who to select. We do conduct a background check.
Okay. And do they have one staff member, or can they decide how many staff members they want? How does that work, or is that up to them?
I believe it's up to them,
Okay, so depending on how much money, I guess, they bring in.
and how much work they have and all of that.
Right, exactly. One of the marshal's offices is listed under fiduciary management, quote unquote. What does that mean? What are the implications of that designation, if that's true?
So my understanding is that when a marshal passes away and their work is ongoing, they are required to have had available a fiduciary to wind down their business, to ensure that all of their records are in place, so that they are also required, to turn over all those records are required to be turned over to DOI after a marshal passes away. So I believe when a marshal's office is in fiduciary status, that is what that means. And there is one that I'm aware of that is in that status.
Okay. So from the DOI's perspective, it doesn't really matter who has a majority of the work. It depends on who gets the work, basically. In other words, and that's how it is. In other words, if you're doing, well, I assume if you have too much work and you're a marshal, then you would recommend the work that is coming in to somebody else. Is that kind of how it works as far as you know? I know it's hard for you to know.
It's not something we control, and it's not something that I am aware of. Certainly, if someone had so much work that they weren't able to do it in an appropriate way, that might generate a concern that would come our way. But other than that, I think you're right. It's not something that we're involved in, have awareness of, have a position on.
Okay. I was certainly aware of finance as well. What does NYCHA have work-wise that is relevant to marshals? Maybe you mentioned it. I know you mentioned NYCHA. I certainly know what finance does. But what would NYCHA do? Is that evictions also?
Evictions, correct.
that's
There may be some other things as well, but evictions is what I'm primarily aware of.
Okay. And then the Department of Finance. Now, if you're a private citizen and you want to, I have a friend who has a business, and she called a marshal because she wasn't being paid by her customers. Is that something that is normal for individuals who are marshals to then go and get that judgment? So anybody can call a marshal to get a judgment that is not being paid. Is that the idea?
Yeah, enforcement of a money judgment is one
Correct.
of their responsibilities. So yeah, that's right.
Okay. And if there's a problem, then they would, with that not happening, then they would contact the Department of Investigation to say this marshal has not been fulfilling his or her duties. Is that correct?
I mean, certainly if someone hired a marshal and they weren't doing the work that was assigned, or they were not doing it in a proper way, that's something that we could receive a complaint about.
Last two questions. Which one? I did this one. I did this one already. Okay. Okay. All right. So then, if there is a complaint from somebody who hasn't felt that the marshal is doing the right thing, what is the exact procedure? Do they call DOI and then there's a response that is, how does that work?
Well, if they were to call us, we would determine the nature of the complaint, the nature of the issue. We provide the marshal with notice of the complaint and give them an opportunity to respond. And depending on the nature of the complaint, we would do whatever investigation we feel is necessary. It could involve looking at records to see, was there a judgment issued? Was that judgment given to the marshal? What did they do with it? In the example that you raised, if it was misconduct of some kind in connection with an eviction, we might try to figure out what happened at the building. Is there a camera? Does the tenant provide us with any video footage? Does the building have a camera with footage? So we would sort of undertake the steps you would expect to try to figure out the facts in terms of what happened, and then the determination of any appropriate penalty would flow from that, if any.
Okay. Also, is there oversight? I sort of asked this before regarding the marshal's behavior and interactions with the public. In other words, that's also where I'm asking you to do more of an informal survey of the offices by just calling, seeing what kind of response you get. Are there any other ideas? Just because even though they are private individuals, I bet the public thinks that they are individuals who work for the city of New York. And so they would expect a certain level of expertise and professionalism.
I mean, as do we, and I do think that we have, as I indicated, received complaints on occasion that a marshal's not conducting themselves in a civil and decent manner, and those are things that we look into. Those are things that, if substantiated, could result in discipline. And I take your point on the value of a sort of informal integrity test of that interaction, if you will.
Okay. And then, now you mentioned that, how would one determine that the office of the sheriff would be involved with any of these activities? Obviously the public, I'll be honest with you, would prefer to have the office of the sheriff because they are, at least when I talk about the tenants and legal aid, because they are city employees and they feel they have a better oversight over city employees than individuals who don't work specifically for the city. So, but you mentioned earlier that maybe the office of the sheriff does do some of this work. How does that get allocated, if at all?
So again, it's really the same process, and this is a part of this work that we don't really play a role in. A private person who is seeking to evict a tenant, for example, could go to the sheriff. My sense is, as you say, that the sheriff's office does relatively few evictions compared to the marshals, though they do some. But that's really up to the entity that is selecting a person to do this work, whether they want to pick a sheriff or a marshal. The fees are consistent, as we said, so it may come down ultimately to a question of relationships. And again, I'm really just guessing because we don't see that process and we're not part of that decision.
Okay, and do you have a sense from the Department of Finance or particularly from Finance, that the work that is done by the marshals is satisfactory to the Department of Finance? Because they obviously have parking, they have judgments, they have all other kinds of probably less controversial and not as heart-wrenching, shall we say. But do you have some sense that that goes well for the Department of Finance? Do you have any contact with the commissioner or anything?
I mean, I certainly haven't had any contact to suggest that it's not going well. We do oversee the marshals with respect to all their work. So if a complaint were to arise from work done for the Department of Finance, either by the department or by a private citizen affected by that work, that complaint would come to us. But I'm not aware of any issues with their work for the Department of Finance.
So I guess my final question is, obviously you're going to work on the issue of APS, because I don't think it's going well. Just 2 cases this week, as an example. And then secondly, to see if there's some kind of informal oversight that can be done with the offices, because people think they're city employees, and why are they not responding in a professional way? And then I hope you would, as you do, keep in contact with those who are, seeking maybe the portal and changes that legal aid has suggested. I also think that at some point there should be a discussion with the state, not you, to see if this is the best way to carry out the duties that have to be carried out. We're talking about cars, financial, and evictions. Is this the best method? Again, it's been around since, 1600, something like that?
A long time.
A
yes.
long time. Well, that's
Goes back to the Dutch, I believe.
Exactly. So the question is it, still the right way to do things? And that's something not for you to determine, but I think for those of us in public policy to say to the state, I don't know, to the courts, I don't know, but let's have a discussion. Because if it's financially more beneficial to do it and certainly maybe better oversight, something to think about. All right. Anything else? No. Thank you very much, and we look forward to continuing to discuss this topic. Thank you so much for your testimony.
Thank you.
So now I open the hearing for public testimony. I remind members of the public that this is a government proceeding and that decorum will be observed. As such, members of the public will remain silent. The witness table is reserved for people who wish to testify. No video recording or photography is allowed from the witness table. Members of the public may not present audio or video recordings as testimony, but may submit transcripts of such recording to the Sergeant at Arms for inclusion in the hearing record. If you wish to speak in today's hearing, please fill out an appearance card with the Sergeant at Arms and wait to be recognized. When recognized, you will have 2 minutes to speak on today's oversight topic, which is the Department of Investigation's oversight of New York City's marshals. If you have a written statement and you want to submit it for the record, please provide a copy of that testimony to the Sergeant at Arms. You can also email any written testimony to testimony@council.nyc.gov within 72 hours of the close of this hearing. We do not take audio and video recordings. For in-person panelists, please come up to the table once your name has been called. For virtual panelists, if there are any, once your name is called, a member of our staff will unmute you and the sergeant will set a timer and you can go ahead and begin to speak. Please wait for the sergeant to announce that you may begin before delivering your testimony. And I am delighted from the Legal Aid Society, Naqib Sadiq, and please come up to the witness table. Thank you so much, Sadiq.
Good morning.
There you go.
Okay, thank you. Good morning, everybody. Thank you very much, council members for having me here. My name is Naqib Sadiq. I'm a supervising attorney with the Legal Aid Society's Harlem Community Legal Office, and I'm a housing attorney. I've been doing that with the Legal Aid Society since 2011. I think the members here are familiar with the Legal Aid Society, so I won't belabor it, but we've been around here since 1876. I always like to tell folks in my office that's longer than the city of New York has been the city of New York as we know it, and I'm proud to work there. And I just want to briefly address some of the points I think you, council member, have already mentioned, asking the commissioner. We're really here to raise just 2 points. One, again, it's already been raised here. As advocates, we, in the course of our work in terms of eviction defense, in some percentage of cases, it inevitably becomes necessary to have to monitor a warrant of eviction. Without getting into the details and the weeds of it, it's the pointy end of the stick. There's some number of cases, some number of tenants, low-income tenants, who face eviction. It may be that just the law, such as it is, will ultimately require their eviction, or more often, they're waiting. They're waiting for an agency to come through. Often the city's Human Resources Administration, they're waiting for some other contingencies to happen to hopefully avoid eviction in the case of a non-payment case. And so I think the members here may already know, the housing court can be a protracted process. It can take months, and it often becomes the situation where there is a final judgment of eviction entered against the tenant, and pursuant to that, the court issues a warrant of eviction, typically to a city marshal, very rarely to a sheriff, but usually to a city marshal. And those marshals those warrants we have to monitor, and we typically do that by calling the marshals. Most cases, my personal experience, the marshals are very helpful. They take a lot of these calls from hundreds of advocates around the city, and that's not even including pro se tenants. And often what we ask is, has a marshal's notice been served? What's the date on the marshal's notice? When is the eviction scheduled? And this happens basically every single business day. We've gotten some reports from our sibling organizations, folks in our office, pro se tenants, that sometimes some marshals, their staff, are not as willing to give out that information, or they say call back later, or send me a fax or an email. And that's something. It's one thing for lawyers to do. It's an inconvenience, but for pro se tenants, that could be a barrier to knowing when this very serious thing could possibly happen. And so one recommendation we have here has already been raised in this oversight meeting, is that there should be a rule or a law that compels city marshals and sheriffs to upload an eviction notice to the state court's electronic system. It's called NYSEF, NYSCEF. It's existed since the height of the pandemic, June 2020. The vast majority of eviction cases in New York City are on NYSEF. I would respectfully submit that I had not heard the commissioner mentioned that there was a portal. I personally have not seen that. I would respectfully submit that it would be far better to use the existing system, NYSEF, which I give QR codes to folks who come into the courthouse every day, and I tell clients, and certainly pro ses, you need to go to this public website and bookmark the docket for your case. It's no longer the case that people need to schlep down to the housing court to get their court files. You can look it up with a smartphone at home on your computer, and that's how most people get the information. We really think a simple fix to tenants not getting a notice of eviction, that does happen sometimes. We see it all the time. This person says, I just didn't get it in the mail, and they get evicted, and it's a disaster. We think a simple and expedient measure, I think that would actually save resources on the marshal side. We would be calling way less frequently. We could simply go to NYSEF, and if tenants could go to NYSEF and see the marshal's notice right there. It would also help agencies like Adult Protective Services, HRA. Judges sometimes want to see when was the last marshal's notice. And honestly, even in those terrible situations when a tenant ultimately gets evicted and they have to, for example, go to shelter, you need to have a lot of documents, right? It's very hard to be a poor person in the city. One of the things you have to do is carry around a bunch of documents. In 2024, we don't really need to do that. One thing that could be really helpful for folks is just to be able to refer to the docket, where all the papers in the case should really be. And there actually already is on NYSEF a setting, so nothing would have to change, that says marshal or sheriff's certificate of service. And they could simply use that to upload the marshal's notice every single time, or we could ask the court system to create a dedicated designation. So that, I guess I'll just leave it there. I think that would be something, not a portal, portal's fine, but I think NICEF would really be the easiest and best method to help notify tenants and their advocates and agencies about impending evictions. Thank you.
Thank you. We will certainly absolutely follow up. Do you have questions for him at all? Okay. One other question I have, though, is APS, because we don't find that it's a seamless process. And I didn't know if that's something that you, because this, like I said, as you heard earlier, we have two situations, one mentally ill, one very, very elderly, that were not referred to APS. So there's a challenge there, and I didn't know if that's something that you come across or any of your associates.
I absolutely, I agree. That happens quite frequently. Again, different marshals' offices and different staffs are, I don't want to take anything away from the marshals and their staff. Some of them are wonderful. They really do take, but the vast majority of them, the section in the marshal's handbook, it's right at the top, section 1.1-2, talks about respect for the public, and it holds the marshals to the highest standards. And I do think a lot of the folks at the marshal's office are sensitive and helpful, but it is like manual transmission. Unless they receive some information that requires them to notify APS, Adult Protective Services, there is no there. So often what we do as advocates, we are the first time that the marshal is hearing so-and-so who's scheduled for eviction tomorrow is disabled, is 95 years old, or has other issues. So there is, I absolutely, there's definitely a gap there. Sometimes judges, which is great, will on their own initiative require the marshal to make an APS referral. Not all judges do that. Sometimes it's not obvious to the judge that this is a vulnerable person. So I think that coordination is super helpful, would be super helpful and important. I do find in my personal experience, most marshals are sensitive. They don't they don't want to be also evicting somebody who's really elderly and vulnerable. That's not really something they want to do. So I think there is an area there that we could all work together, all the stakeholders.
All right. And in terms of, I certainly want to implement your NICEF suggestion. Is that something we can do on the city level, as far as you know? It doesn't have to go through the state or the court, to the best of your knowledge?
Yeah, to the best of my knowledge, Councilmember Brewer, I was about to call you judge, but to the best of my knowledge, I think it can be done by DOI, pursuant to a special order. They have directives that they're allowed to do. The two.
We could also pass a law directing them to have the directive.
Yes, Judge. I think that's right. And
then there's no. I don't know if this is. Then it's clear.
That's right. I think my understanding is the two appellate divisions, the first and the second department, they only have to approve full revisions of the Marshal's Handbook. Although I'll just note, the last revision of the Marshal's Handbook was in 2013. A lot has happened in this country and the city since 2013. I think it's probably overdue, but that does require, I think, the judiciary to weigh in on. But I think a simpler method is what the commissioner has been doing, certainly during the height of the pandemic with the state laws that happened in 2019. If you look at the text of the Marshal's Handbook, it talks about 6-day notices because it was written in 2013. But the directives that the commissioner issued in 2019 make it clear to the marshals that no, the state law has changed. Now you have to give 14 days notice because the legislature changed the rules around how much time you get before an eviction can be carried out. So similarly, I think it could just be a simple directive directing marshals or landlords' attorneys, whatever agents before an eviction is carried out. I would submit commercial and residential. Why not? I think marshals, from my experience, they are on NICEF. Their staff is on NICEF all day long. They're actually consulting it in real time. This would not be an additional step. It is an additional step, but it would be one that I think would save time because fewer people would be calling them. And it's just in the interest of transparency and dignity for especially unrepresented folks and agencies to be able to see in real time. Because that's the other thing here. Parties don't have to. No unrepresented party in New York State is required to use electronic filing, but the nice thing about our e-filing law in New York State is any unrepresented person can opt in or opt out at any moment for any reason. So some number of tenants I've encountered who are either represented by the Legal Aid Society or one of our siblings, or is unrepresented, some number of folks are like, yeah, I will opt in because I want notifications sent to me in email in real time. And I think increasingly we'll see that happen. I think most folks, especially as, you know, a lot of folks are very technologically savvy. They don't really want to wait for a paper, like who gets snail mail anyway, right? And this is not the kind of, you know.
Me.
I do as well, council member, I do as well, but, you know, and certainly we're not saying that this should be in lieu of whatever the law requires in terms of service of papers. It's just an additional security belt, and I'll just analogize to how the court system in New York City, housing court, they send postcards to tenants to say, hey, here's your next court date. They don't have to do that. The state law does not require that, but in the city of 8.5 million people, and it's a humanitarian gesture. It's helpful because sometimes tenants say all the time, hey, I got the postcard. I didn't get the papers the landlord sent to me. I didn't get the marshal's notice, but I got this postcard. Similarly, I think if we can use electronic notification, why not? It exists. I think it would save a lot of heartache and time and effort for everybody involved.
We've been joined by Councilmember Kristen, who knows everything about this topic. Do you have any questions? We're about to end. Yeah. Okay, go ahead.
Well, thank you, Chair Brewer. And yes, fortunately and unfortunately, I have a lot of experience with these issues. And so that's why, and one thing in particular I wanted to raise, and you sort of already touched on it too, with the APS referrals. But one of the biggest problems that we see now that I think is even undercounted is the alarming spike and presence of illegal evictions in our city, where there are no court orders and landlords are changing locks on tenants, putting their things out on the street overnight. And so I know you all operate based on the court system, and you're checking NICEF and making sure that it's where things are on the docket. But I'm just wondering what work you all are doing, given how traumatic evictions are as well, to make sure that you have the most up-to-date information, that you actually have a warrant and a final order of eviction before proceeding with anything, and are not being misled by baseless proceedings or illegal evictions.
Yeah, thank you. I think you're absolutely right. I mean, that has been a perennial problem, and certainly I think in the last few years, during the height of the pandemic, a lot of landlords and even roommates, other folks have resorted to self-help. It's wrong. It's a misdemeanor. Wrong in a criminal sense. It's actually a misdemeanor in the city of New York. You know, I guess I would just go back again to saying, you know, the subject of this kind of conversation about oversight of Department of Investigations. It is really, really important, I think, for all parties, and I always tell this to tenants, go directly to the source, which is the court. Right? In the old days, people would have to go physically to the courthouse, and some people still want that experience. Like, they want to see somebody face to face, and that's fine. The courthouse is open. It's a public courthouse. It's our courthouse. But I would again say NICEF is super important. It's maybe not the most user-friendly, but it's also not particularly complicated for most folks to navigate. Their tenants can find a huge amount of information. Their advocates, agencies that they're working with, previous types of cases. You can find information on your same landlord. You can just do a word search. And those kinds of, so really I think the docket, the vast volume of information that we have, right, in an unfortunate way, the legal system is like a library, like the worst kind of library that there is, but it's a social record, right? You can find a huge amount of information, and it used to be locked away in these, you know, in the courthouse, in these dusty files. You got to go there with your quarters and make photocopies. You don't have to do that anymore. And I think it could be really, really empowering to tenants' rights advocates, tenants themselves, people in communities, electeds, you know, advocating for folks to be able to keep an eye on the bad actors and spot these trends, especially using the databases that we have. I think starting fundamentally with the e-filing system that the court has. That, I think, is really the key.
Thank you, and appreciate, you know, how it's really a collective effort from the advocate side, from the agency side, to make sure that, you know, those kinds of illegal evictions aren't happening, and that the tenants get proper process and their rights are respected. So, but I appreciate your answer, and thank you, Chair Brewer, for holding a hearing on a topic that's very important, but does not get as much attention as it should. But thank you.
Thank you very much. You are a fabulous witness.
Thank you very much. Have a nice day. Be well.
Agreed.
Take care.
And we have one witness from Zoom. So wait for the Sergeant at Arms to announce that you may begin, and then you can begin your testimony. It's Christopher Leon Johnson.
Starting time.
Hello, can you hear me?
We can hear you.
Oh yeah, hey, my name is Christopher Leon Johnson, and I am a renter. I live in Brooklyn. I can't say the exact address. I'm at this Susan's Wong event right now, so couldn't be in person. But I'm gonna say this right now to a lot of people. You know, I know the reason there's not a lot of people here because they're scared, and I don't blame them because people like to retaliate. But I'll make this clear. The DOI needs to start investigating on how these people get appointed as marshals. And the problem is, like I said, they need to start investigating how these people get appointed as marshals because a lot of these marshals could be real shady. They could do a lot of shady stuff, and mainly it's all about aggressively evicting people. And I think that's the problem with a lot of people. They not to say it public, but I'll say it, is the way they evict people. I understand like they got to do their job and evict people, but if you aggressively try to force them like you're a cop, injuring people, then there's a big issue with that, you know? So I know a lot of people ain't gonna come out and say anything because they're scared of retaliation. But people know what my name is Christopher Leon Johnson. Go look it up. And like I said, it just need to stop. You know what I'm saying? Thank you, Gail, for doing that. I know it's kind of brave of you for doing this hearing. I know a lot of people are coming out to say that because they're scared of retaliation. It's violent evictions. That's the problem. It's violent evictions. It's not an eviction problem. It's violent evictions, and it's all about making sure that market rate apartments get made in New York City for the developers. That's why they have no issue of trying to evict rent regulated people. Like I said, the marshals, they're just doing their job, but the way they do it is disgusting. They do it to a lot of people, aggressively pull people out, and some of them are sadists. They get off on people crying.
Thank you. Your time has expired.
Thank you so much. Thank you.
Thank you.
Thank you.
We've now heard from everyone who has signed up to testify. If we missed anyone who would like to testify in person, visit the sergeant's table, complete a witness slip. If we inadvertently missed anyone who would like to testify virtually, please use the raise hand function in Zoom, and we will call on you in the order of hands raised. Okay, we want to know if Charlie Linehan is here. Seeing no one else unless he's here and he's not online. I would like to note that written testimony, which will be reviewed in full by committee staff, may be submitted to the record up to 72 hours after the close of this hearing by emailing it to testimony@council.nyc.gov. I want to thank the Sergeant at Arms and my colleagues. And this is a topic that I think has been around the marshals since the Dutch were here. And we'd have to consider if this is still relevant from those times. Thank you very much. This hearing is concluded.